back to the PI show, your forum for discussing your rights in personal injury law. It's now time for Viv's mailbag with Vivian Ryan, who brings us your questions each week. Good evening, Vivian.
Good evening, guys. Welcome, viewers. Thanks so much for all of the emails you've been sending in over the last few weeks. It's always great to receive feedback from you all. Our first question comes from Heidi in Burwood, guys. She says, Dear Harry, Tony and Viv, I broke my ankle when I fell down the stairs at work about 6 months ago. Recently, the pain has become so bad that I'm unable to get out of bed, and the doctor says I may need to have an operation. I haven't been able to work since the accident because of the very strong medication that I'm on. Would I have a claim against my employer or against someone else? Thanks, Heidi. What do you have to say about that, Harry?
Heidi, it's a work accident, so there's what's called statutory benefits. So your weekly payments and the payment for the operation for the ankle should be paid for by WorkCover. Hopefully you've seen a lawyer by now and put in a claim. The claim should be made as soon as practical. And the important thing is it's an accepted claim, so all your what's called statutory benefit, weekly payments, medical expenses should be covered whilst you're off work and injured. Secondly, you've got a right to what's called no-fault benefits for pain and suffering. That has a time lapse of 12 months. So before you can put in a claim for that, you've got to wait 12 months, see how the injuries resolves. For the no-fault benefit, you need 10% whole person impairment. There's a sort of a threshold that you need to get. And thirdly, you can wait 18 months and consider whether you can sue an employer at common law for damages, but you need to prove fault. So there's either the employer or perhaps the owner of the building. The stairs are faulty. There's faulty lighting. There could be all sorts of issues about that. If you're coming to see us, the first thing we'd say is take photos of the scene of the accident so the lawyer can then discuss that claim.
Harry, the only thing I'd like to add to that is basically just extrapolate on what you said at the end. I think you just got to get the facts right as to what happened. The stairs are crucial. We need to get some video or pictures of the stairs, lighting, like you said. Maybe get an expert out there if necessary, because what invariably happens in these cases is that the actual scenario changes in the future. By the time you actually get to a common law situation where you can investigate and properly prosecute the claim, you're looking at about 2, maybe 3 years down the track. So it's important that you preserve the evidence. Anyway.
Well, Heidi, quite a detailed answer for you. I hope that's helped you somewhat. The next question comes from Maria, who lives in South Morang. She says, Hi Viv, recently my 10-year-old son had a friend over, and while they were playing footy in the backyard, his friend fell over and broke his arm. I did not leave them unsupervised and the whole event was an accident. However, his mother was extremely agitated and she's threatened to sue me. I am now worried I will have to cover his medical expenses, which I don't think I can afford at the moment. How likely is she to succeed against me? Tony?
Well, Maria, the real problem is that you need to know more about the facts. I mean, the fact that you're playing footy, it's something that happens every day. You got kids of all ages playing footy. You got them at the age of 4, 5, 6, 7, 18 in the street, you know. So, I mean, that itself is not going to get, it's not going to advance a claim in public liability. But what you might have to do is look at the circumstance. You might have put your foot in a pothole, or they might have been digging up the garden or something like that. So then that might give you a look in for public liability. But the other thing also is the fact that, broken arm these days doesn't satisfy the 5% threshold. You know, under the law, you've got the AMA guides we work under, which is the American Medical Association, and broken arm, unless there's complications with it, there's nerve damage or something like that, will probably not get you over 5%. And also, the other thing is, does the owner of the house have insurance? That's a critical issue, I think, Harry. I mean, as a rule, you don't want to sue if there's no one to cover the cost of these claims. So, yeah, look, it's something that you'd probably need to get advice on, because I think it's a difficult one.
Prima facie, there's got to be fault. Before there's any possible claim, there's got to be some circumstance where someone is at fault, and on the face of it, doesn't seem to be anyone at fault. So the mother of the son who has medical expenses is very unfortunate. may not be able to bring a claim at all because unless there's something unusual, there's no fault.
So even the fact that it's in her backyard, I know earlier, Tony, you mentioned that it could potentially be a public liability claim.
It could. Look, there might be a massive gaping hole in the backyard and they fell into that. That could open up the door, you know. But it can't be obvious. It has to be like a hidden traps type scenario. So, and you know, the playing footy, it's something that happens every day, Viv.
So Maria probably could rest
Get
assured that
advice.
it's unlikely that...
It's unlikely at this stage.
I still think she
Yeah.
should make a phone call and get some proper advice.
Okay, great. The third question comes from Andy in Bacchus Marsh. He says, "Hi, the other day when I was at the park, I threw a ball to my dog, which is a rather large German Shepherd. While he was chasing it, he knocked over a toddler who hit his head on the ground. Ooh. I immediately apologised to his parents, but they requested my details. I'm not sure what's going to happen now. Is it possible that I could be sued? I'm really worried and would love some advice. Thanks, Andy." Harry?
Well, Andy's a defendant, and the first thing he should look at is his household insurance and see whether he's got household insurance covering this situation. If he does, contact the insurer, and they will then investigate the claim on his behalf. Assuming he's got insurance, the insurer would be concerned if there's significant damage to the toddler, in the sense of he's got a serious long-term injury. A toddler has legal rights open till the age of 18 plus 3 years. So it's a long tail, it's called a long tail claim. So until the assessment of the injury is made, it's hard to put an estimate on what the claim's worth from the point of view of an insurer. But I think it's something that Andy should contact his insurer and they will investigate the claim on his behalf.
Yeah, the only thing I'd like to add, Harry, is that I think Andy's in the gun. I mean, he should have had the dog on a leash and properly secured.
But
So I think-
but people throw balls to dogs all the time in parks. I mean,
There's a pretty strict liability under what's called the Dog Act legislation where if a dog causes someone injuries, then the owner of the dog is liable. It's quite a high threshold of liability. Tony, that's all we've got time for. We'll be back next week to talk about airline injuries. Martin Smith's on his way back and he'll zoom in and talk to us about airline injuries. Thanks for watching. See you next week.
Thanks, you guys. Thanks, Viv.
bye.
Harry.
Thanks,